share beneficial information about the intellectual properties with us. Okay? Let's welcome Dr. Kapoor.
Unfortunately, all those points that Dr. Siok just described doesn't relate to my topic of the talk today. But I'll tell you why I am here discussing about this topic, that is creating and protecting intellectual assets. Like, although I'm a researcher, I have my own lab, I guide my own PhD students, but at the same time I've voluntarily took up additional responsibility in my university, that is identifying the technologies at a seed stage and helping the research scholars and my fellow colleagues to protect it, or to protect it, that is through patenting. So my job is, and my university, that's an additional job, and this I've taken up because apart from being an assistant professor, I'm also an Indian patent agent in my university. So a patent agent, as you know, is authorized to file and prosecute on behalf of their own clients. So all the patent filings and prosecution which are from my university, so I take care of that. So the topic today is creating and protecting intellectual assets. So I'll tell you what is the plan of the seminar today. I'll first very briefly introduce you what is intellectual property. This I'll do it very quickly because this is not the focus of the talk today. And I'll take you through the types of patent applications. Different types of patent applications are there, and what's the significance of each of these patent applications, and what's the benefit and what's the drawbacks. We'll discuss that. And I have gathered some data on US universities about how much do they patent, and I've tried to compare that, and how much revenue do they generate through the patenting and licensing. At last, I'll be discussing about two ideas. How should one go about generating new ideas? How should one, what is the methodology, or what is the way by which we can really create intellectual assets? So the last part would be interesting, and first part would be now types of patent applications. I'll be discussing about provisional patent application, the non-provisional, design, PAN patent. These are not of immediate relevance to us, so I will be skipping design patent and PAN patent. I'll be discussing more about the provisional patent application. Now, the provisional patent application is very important for especially the students. Why I'm saying, because I know that every university now has its own patenting and licensing office, so most of the faculty who are generating their ideas and want to protect it, they can approach the IP cell, which will take care of their cost and all the written part, everything can be done. But for a student who comes up with a new idea and doesn't have the money or doesn't have the expertise to protect the idea, for them provisional patent application is something which you should be aware of. It preserves the international filing right, means the moment you file a provisional patent application, you get a priority date. That priority date secures your invention, because by that you were the first to file that invention. It defers substantial patent cost. I checked the website of USPTO, and I found that the cost of filing a provisional patent application is $135. So you can just protect your idea with $135. Now, it permits invention to be marked as patent pending. So once you have filed a provisional patent application, you have the time to sell your idea. You have the time to convert your idea into a product. You have the time to go to the market and to find a vendor, a company who is interested in your product. So a provisional patent application has tremendous application, and especially for the small entities like individuals or the people who don't have the money to go for a proper hire an attorney and then go for it. So by just saying that patent pending, you can sell your idea. Now, what does a provisional patent application require? If you want to write a provisional patent application, you just have to write a title, you have to write a field of invention, you have to write a background, and after background comes the summary of invention, and at last you just have to specify how to enable the technology, how have you enabled the technology, what is to be done. So this is the format in which you will write the patent application, and this is very simple, anybody can do. The most tricky part in any patent application is the claims, and you don't have to write claims in a provisional patent application. You can just disclose your idea in substantial detail. That is more important, and the details should also include the pictures, how you devise it, what are the diagrams and that. So you have to give as much description as you can, and you secure your invention through provisional patent application. Now, what happens to a provisional patent application? It is not examined by the USPTO, and if it is not examined, it won't be published. So that's another good thing, that your idea still is there, it is not published. But you get a time period of 12 months in which you have to go for a RPA, regular patent application. If you don't, by the time of 12 months, if you don't find your idea someone who is interested in you, if you're not able to license it out, or if you're not able to sell it out, then you can decide not to go for a regular patent application. So your idea still remains hidden, right? So it does not form the basis of enforceable patent protection. That means if you find someone using the same idea, you cannot enforce by virtue of law to stop that guy, or to sue him, or to get some damage out of it. So it is not enforceable, and this is the filing fees, and it requires very minimal fees for legal services. This I have already discussed, that you just have to disclose the idea. Now, what happens after the provisional patent application is filed? That USPTO does nothing, and it is never published, and no patentability search is carried out, and it secures your priority date. Now we come to the utility application, which follows the provisional patent application. So it must be filed within 1 year of the application. This is formally examined. If I say examined, then the examiner will do prior art searches for your invention. And it is good if you can yourself do some prior art searches before going for a regular patent application. That's a good thing, because if the examiner finds a prior art, he will just reject your application, and you lose the cost of filing the application. So if you can yourself assess the patentability of your idea, so that will be a good thing. So for that, I'll discuss that thing about how to search yourself. Now, the other form of the application is conventional application. In Paris Convention Treaty, which was held in 1883, it provides reciprocity in filing with the rights of priority. There are 175 countries who are signatory to Paris Convention Treaty, and if you're filing in US and you think that my invention can also sell in India, so you have 12 months time, and Indian Patent Office will recognize your priority date as the same as you did with the US Patent Office. So this is a treaty which is signed between 175 countries. It secures your priority date for 12 months. So this is the convention application. You can move into any country within 12 months of filing in your own country. The next is the international patent organizations. You can also file to WIPO, which is located in Geneva, World Intellectual Property Organization. You can also, this has 148 countries which are signatory to WIPO treaty. I'll come to this again. And European Patent Office is again, all the European countries are covered under the single patent office. And ARIPO is, if you has 18 members, that is African Regional Intellectual Property Organization. You can find in these organizations to secure your invention and their member states. Now PCT is a very useful route for, if you think that your invention can be used worldwide. It has potential in different countries, it has good market in many other countries. So the best route to file your application is through PCT. What is PCT? PCT is, we call it as WIPO, World Intellectual Property Organization, and US or India, they are the receiving office. US Patent Office will receive your application. It will transmit your application to WIPO in Geneva, and you get a 30 months time to go into any country which is signatory. So 30 months is good enough time. You get more than 2 years to make sure that your application, wherever it has a market, goes into that particular country. So 30 months time, there is no other way you can get. This is a very good way of securing your invention in many different countries. So PCT is the best route if you find that your invention has a global market. Now, I've just gathered some encouraging facts about US University. I was just wondering how good university are performing and how many patents do they file. So I just, this was a paper which I came across. This was published in Nature Biotechnology. It ranks different universities according to the money they are generating through their licenses and how many startups they have. Again, this is just for out of curiosity I put this line. And one thing which is encouraging the life sciences is that you can see the life sciences is the major source of revenue for any university. That is, I was also surprised because I was thinking that it's computers and the softwares and like Intel and which is generated in Stanford, they are the major share of the generation of the revenue. But I found that life sciences are the one which is contributing majorly to the revenues. So that's an encouraging thing for us because we are all from life sciences. Then I compared different universities with University of Arkansas. So I found one references, there is university that was in Chronicles of Higher Education, which says that University of Arkansas generates 9.1 million USD. And when I checked the number of patents which are filed, it is 560 patent applications that has been filed by University of Arkansas till date. I'm only referring to the applications. I don't know how many patents have been granted. It could be only 15, it could be only 20. But these many patent applications were filed from University of Arkansas. And this is, I tried to figure out what was the golden period of University of Arkansas. So I found that 2010 there were 44 applications that were filed from University of Arkansas. And then I figured out who is the top inventor in University of Arkansas. So I found these names, James Norman, and you must be knowing these people, I don't know, but this is just for your information that these are your top inventors. And Briz, he works on nanoparticles, and Sheng Zensky works on superconductors, Cook Arton works on textiles, and Dr. O'Brien Timothy works on ovarian cancer. Similarly, Eaton and Daniel, they work on test processes. There were many others which I didn't list it, but these are the top inventors in the university. So this was just... Now I come to the main part of this talk, that how to create. How can you create ideas? Now, why generally we follow the mentality of like you publish your work or you perish. So this goes on in academics, like you publish or you perish. So we have this mentality that if you want to secure a good position, if you want to grow in your career, you publish your work and That's one of the way to secure your career and grow high in the academics. And we generally don't have enough funds. We have good ideas, but we don't have enough funds to support our ideas. And one of the papers which said that there is some intrusion of the politics also into the support. So I've just listed down, these could be the different problems that are coming, are faced by the university staff. And in this picture you can see that there's a heap of journals which nobody reads. Okay, so what's the way is that if we are publishing a work prior to filing a patent, that is not good. But if you are first filing a patent, then publishing it, that's a real way of moving ahead. So it's as simple as that. So you should first think whether this is patentable or not. Only then you have to decide for the publication part. Now, how to decide the patentability? How to make sure that your idea is patentable? So you have to carry out a prior art search. You can do the prior arts in patent literature or in non-patent literature. You have to do both the things, because this is how the patent examiners, they check your novelty of your invention. Now for searching patents, you have to make sure that patents are not written to be found. This is something, if you read a patent document, they will not say a pen is not a pen, it is a writing device. So they will never call it as a pen. They don't want that the patent should be discovered, but they will suddenly come up once you start selling those pens. That, oh see, we got it patented earlier. So catching a patent or doing a prior art search is really tricky. You have to really play around the words. For example, I was asked to do a prior art search on magnetic beads. So I found a patent which didn't refer a magnet to be magnet. It referred it to as a lodestone. Lodestone, nobody knows what is a lodestone. Someone of you might be knowing, but it's also a magnetic particle. So it says that antibody immobilized on a lodestone. So they try their best to keep themselves hidden, but they will certainly jump on when the moment they find that you are growing big and you have a lot of money, so they can sue you. So you have to be very tricky while doing prior art searches. So titles are not the best thing to limit your search when you're searching. I hope you're aware of most of the search engines. It gives an option of searching in title, abstract, or title, abstract, and claims. So if you want to reduce your work by just limiting your search to the title, then you'll be missing a lot of patterns. So don't restrict your search. Always do a full text analysis. And while using operators, if you use any journal database, it provides 3 operators: and, or, and not. But if you go for a dedicated patent search database, for example Thomson Innovation, they provide certain other operators like near 2, near 3. So it searches both the way. And the operator adjacent searches only adjacent. But if you use the operator near, if the word is this side or that side, it will search both the things. So you have to be choosy about your database and the operators also. So you can do searches based on application number, patent number, assignee name, inventor name, subject search. So these are different ways you can search for your prior art. Now, coming on to the next part is about patent landscape studies. What are these, and why I always encourage each and every academician to carry out a patent landscape study, because it gives you a whole wealth of information. A patent landscape study with a single step which are related to that particular technology. Then we develop a taxonomy based on which we categorize the information which is present in the patent, and through graphical means we picturize, we make it very convenient for you to understand that how and where and who and how are into this game. So there's a set methodology of doing this.
Okay, but is that methodology published, or is this something that you're selling?
It can be done by you also. It can be done by anybody. But it is why? Because I was associated with a firm which used to do this, and our clients were in US and Europe, and they were the major companies like Baxter and Kiagan. There was all companies which are getting this done through us, and they were making their decisions based on these kind of studies. So, but we don't have, we as academician, when I came into the academics field, I saw no one doing such kind of studies. And this is how these companies are securing their IP. This is how they are making their executive decisions. Whom to, like they carry out due diligence studies, whom should we buy and whom should we sell and whom to take over, and where is whom should we collaborate with. So this could be useful for, I'm sure it is very useful for academicians also. Like the scientists who are working in universities, they should also do such kind of studies and to find the potential buyers and to whom you can license.